Good luck to you, sir. You can go back with me. Good job.
Oh, you're funny.
I'm getting there. Let's see. I probably don't want to know what you guys are saying. Herbert Kane, 24 DCCR 1083.
We were in Kansas the other day, and literally 20 minutes like this, literally. I was doing a judge. I'm gonna get a So I started speaking to the plea and said, by the way, Judge, she told me off. You got on you?
That's funny. All right, sir. Are you Herbert Kane? Is your name Herbert Kane? And I'm going to take judicial notice in Mr. Kane's file. Mr. Kane was evaluated for competency to stand trial by Dr. Khan. I've received that report dated August 13th of 2024. Dr. Khan made the finding that Mr. Kane is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Parker?
There you go.
Ms. Mulkey? Then at this time, I am going to find that Mr. Kane is competent to stand trial.
This right here is huge. Competent to stand trial doesn't mean innocent or guilty. It simply means the defendant understands what's happening and can assist in his defense. Once the judge makes this finding, the case officially moves forward. There's no pause button after this.
Mr. Kane, you're charged by indictment with the offense of assault on a peace officer, and that is from April 3rd, 2024. And what that means is if you go to trial and a jury finds you guilty, the range of punishment is between 2 years and up to 20 years.
Let's translate that into real-world terms. 2 to 20 years. That's not a slap on the wrist. That's a life-altering range. And notice how calmly the judge delivers it. In court, the most serious consequences are often stated in the calmest voices.
In prison. Do you understand what could happen if you go to trial and you're found guilty? Sure.
I got it. Yes, folks were camping up. I was going like, I just kind of struggled.
So here's the thing. What happened surrounding this offense or what they charged you with, that's information for your lawyer. And if for some reason if you believe you're not guilty, then that's what a jury's for, and we can let your case go to a jury. That's what we're going through. So it looks like the state has made an offer if you wanted to enter a plea of guilty for a 5-year term in prison. You have every right to reject that. Let a jury decide 2 things. The first is to decide if you're guilty or not. And then if they find you guilty, then they can decide what your punishment is. Do you understand? Here's the thing. Well, here's the thing. The offer is, I don't get involved in the negotiations. That's not part of my job. So the state has made their offer. If you want to take it, you can take it. If you don't, then you let a jury decide. And so I just want to make sure you understand if you go to a jury what your options are today and what your consequences could be if you go in front of a jury.
Yeah, I discussed these facts, these concerns with Nichols, explained the situation. He's had evaluated a few that talked about the offer and Mr. Offer. Mr. Nichols' name, she sent that from the offer. No, she stopped.
Okay.
Your lawyer's not instructed.
Okay. Burglary of a building, it sounds like.
I got over.
Okay. So it doesn't appear that it was, but I just want to make sure. Right now we're talking about this case. The offer is what the offer is from the district attorney's office. So you either take it or you go to jury trial. Look, regardless of that, that doesn't change. Even if you had it, it doesn't change the punishment in this one. Okay, that can be figured out by your attorney very easily if you have one or not. So I just need to know if you want to take the 5 years on this case or if you want to go let a jury decide. No, you cannot ask her a question. It's a state jail felony, burglary of a building is what,
Sorry.
go ahead.
Felony conviction of Kelly jail time, so he made this up. Yeah, it's already.
Okay, so it sounds like you got a 1244, which means you got a state jail felony conviction, but you did your time in the Jefferson County Jail. So you do have that state jail felony conviction, even though you did your time.
This is where a lot of defendants get tripped up. A state jail felony doesn't magically disappear just because the time was served in county jail. The label sticks, and that confusion you're hearing, it's incredibly common, and it can cost people dearly if they misunderstand it.
The county jail. That's what the paperwork looks like. It did not get dismissed. It's where you do your punishment in county jail. And I go over all of that with anyone who's in front of me. So I'm sure I did the same with you. It's a state jail felony conviction. But we're going to stop talking about that because it doesn't matter right now. That's a misdemeanor court. Listen, it doesn't matter. Whatever that prior is or is not, does not matter on this case right now. This case that you're charged with, second-degree felony, assault on a peace officer. The district attorney's office has made an offer of 5 years. Take it or go to trial. The prior is not what is enhancing you. It's not changing this. The offer is what the offer is. Do you want it? Or do you want to let a jury decide?
I'm still going to do it for you.
Okay.
Because approximately 100 days.
So hang on a second. You're asking me questions that your attorney has already gone over. Listen, don't talk over me. Listen, and don't talk for me. Because I don't think you've been listening to Mr. Parker. Mr. Parker sounds like has explained everything to you. He's asked the clerk. She has figured out your time, how much credit you have. I don't know how much time. He doesn't know how much time you would actually do on a 5-year sentence because it depends on parole and good time and all of that and how you behave in prison. It's a 5-year sentence. You would be eligible for parole after a quarter of it. That's all we can tell you. And he can tell you how much credit you have. But it's just eligibility for parole. We don't know when you're really going to make it, if you do. That's up to you and how you behave. I need to know if you want to take that or if you want to go to trial. So what do you want to do? Sure.
So you can quarter of that comes from parole.
Mm-hmm.
You can have 100.
Yeah. Okay.
Like 6 months now, I got to get very good time.
So here's the thing. I went to law school because I'm not good at math. I have no idea. Well, do the math. I don't know. I mean, if a quarter of 5 is
About a year.
3/4,
About a year, 2 months.
do you know?
I was trying to make sense.
What?
I make
We're not here for a math test. Do you want to take the deal or do you not want to take the deal?
He asked me today, Judge, if you would get out and take the deal. I said, we're not get out today.
No, you don't get out today. You got to go get your number and do all this stuff. Mr. Parker answered all this. I got other stuff to do. Do you want to take the deal or do you not want to take the deal? It's not going to be on the table after today. If you reject this offer today, I'll set your case for trial. And
This is the moment of truth. The judge is drawing a hard line. Take the deal today, or it's gone forever. This isn't a threat. It's courtroom reality. Prosecutors hate wasted trial slots, and judges hate delay even more.
this offer will be off the table. I want to make sure you understand that as well. I don't accept plea agreements once I put your case on the trial docket. So what do you want to do? Okay. So we'll put your case on. You understand that I'm not going to take this 5-year deal and it's not going to get any better after today. You understand that, right? Because I'm telling you it's not going to get better. I'm not going to accept a plea agreement for less than 5 years after today. Because I don't play with my trial docket and just put cases on it So if somebody thinks, well, make it last a little longer, maybe I'll get a better deal later. This is your deal today. If you don't want this deal, that's fine. It's either going to have a jury decide, which is fine, or the deal is going to be higher, not lower. Do you understand? And I'm not doing this just for everybody on the trial docket. If you want a jury to decide, fine. You want the 5 years? Take it today, because today, 5 years is gone. What you want to do?
Let's see. So you pretty much told me so many words that you weren't going to allow me to beat my case.
Well, no, I'm completely going to allow you to beat your case. If you want to take it to a jury, 100%, we're going to get it set for trial, and you'll be up for trial whenever the next available trial docket is, and a jury can decide if you're guilty or not, and if you're guilty, then they can sentence you to whatever they think is appropriate. So absolutely, I'm telling you that you can try to beat your case. I just want you to understand that if you think you're putting it on the trial docket to buy some time to get a better deal, and then you want to plead guilty later, that's not going to happen.
And here's the irony. The judge is actually protecting the system, not punishing the defendant. You can fight your case, but you can't use the court as a bargaining chip. So the real question is, would you gamble on a jury, knowing the deal only gets worse from here?